And I thank all of our witnesses who are here. We're glad to have all of you here and members of the committee. I recognize myself for 5 minutes for an opening statement. Welcome to today's hearing, The Future of WOTUS, Examining the Role of States. I thank our expert panel of witnesses for being here today and agreeing to testify about this important topic. The Waters of the United States Rule, or WOTUS, issued by the EPA in 2015 amounted to one of the biggest federal overreaches in modern history. Not only did the rule's flimsy definitions and underlying science mean that the agency had the ability to regulate private land, but it also placed significant financial burdens on some of our country's hardest workers. I am very pleased to have representatives here today from my home state of Arizona to discuss how this rule would affect them and what changes they believe would make water regulations better for this country. We all want to be good stewards of the environment. We also want to be good stewards for the people we are here in Washington to represent. When a federal agency overlooks the needs of American citizens, we in Congress have a duty to ask questions and address the concerns of our constituents. For example, when WOTUS was proposed, there was a large outcry from stakeholders across the nation that the rule's vague definitions regarding navigable water could include sometimes dry drainage ditches on private farmland. It's absurd to consider a dry ditch navigable. Our nation depends on the hard work of farmers and ranchers. These men and women simply don't have the time to deal with bureaucratic nonsense. Of course, it's not just them who suffer. Costly and unnecessary government mandates have drastic economic impacts on each and every one of us. The shortcomings of WOTUS are so self-evident that it is not surprising this onerous rule has been challenged across the country. And now we can point to a very encouraging action from the new administration. President Trump recently issued an executive order directing EPA and the Army Corps of Engineers to review the WOTUS rule. I applaud the administration for heeding the calls of Americans. A revision to the 2015 rule is desperately needed to provide greater clarity to states and stakeholders. Instead of rushing forward with burdensome federal regulations, the government needs to do its due diligence and propose a rule that is helpful, not harmful. Today we will hear ideas about how some of those fixes to the regulation should look. Witnesses will inform Congress how federal water regulations affect them and what they need from the government to continue operating effectively. I look forward to a knowledgeable and substantive discussion. And I ask for unanimous consent to enter the comments of the American Road and Transportation Builders Association to the EPA regarding the original WOTUS rule. With that, I yield back and recognize the ranking member, Ms. Bonamici of Oregon, for her opening statement.
Thank you, Mr. Chairman. From Oregon's Willamette Valley to the Chesapeake Bay, Americans want the waters of the United States to be safeguarded from harmful pollutants. They want this protection because our national ecosystem is interconnected, and what happens upstream is going to influence what happens downstream, especially to drinking water. Clean water is essential for our survival, and humanity has been dealing with issues related to access to clean water since the dawn of civilization. The needs of individual states are far more similar than they are different. The Clean Water Act exists in part because there was a time when states had primary responsibility for keeping waters within their state clean and safe. Unfortunately, many of those states were not able to meet that responsibility, and Americans watched as some of those waters became dirty and polluted and others caught on fire. Back in 1972, amendments to the Clean Water Act redefined the waters covered under the Act to include the waters of the United States, including the territorial seas. But court opinions addressing which bodies of water fit that definition have been inconsistent. The genesis of the Clean Water Rule comes from the 2006 U.S. Supreme Court case Rayburn versus United States, in which the court did not reach a majority decision about what constitutes a water of the United States, and the result of that decision was confusion. The purpose of the rule is to minimize confusion by clarifying the jurisdiction of the Clean Water Act. After the Rapanos case, but prior to the rule, the EPA released a report titled Connectivity of Streams and Wetlands to Downstream Waters, a Review and Synthesis of the Scientific Evidence. Mr. Chairman, I ask for unanimous consent to enter the executive summary of this report into the record. The report reviewed more than 1,200 publications from peer-reviewed scientific literature, and the report itself went through 2 separate independent peer reviews. The report drew 5 major conclusions which provided initial support for the Clean Water Rule. One conclusion was the scientific literature unequivocally demonstrates that streams individually or cumulatively exert a strong influence on the integrity of downstream waters. All tributary streams, including perennial, intermittent, and ephemeral streams, are physically, chemically, and biologically connected to downstream rivers. As Mr. Kopocis explains in his testimony, before the Waters of the U.S. rule was finalized in May of 2015, the EPA received and considered more than 1 million public comments and held more than 400 public meetings. And though some suggest that, despite past performance, states rather than the environmental protection agencies should conserve America's waterways, watersheds, rivers, lakes, and streams, in response to such a suggestion in the Rapanos case, former Supreme Court Justice John Paul Stevens said, quote, "The fact that the states have the power and the interest does not necessarily mean that the federal government does not also have the power." Now, I don't want to return to a time when our waters were dirty, polluted, and even caught on fire, and I know our constituents don't want that either. It is for that very reason that we also need to hear not just from witnesses here today, but also from representatives who are currently at the Environmental Protection Agency. This committee must meet its oversight responsibility and question the EPA about this issue and other issues actions they are taking. The quality of the air we breathe and the water we drink is too important. This committee has a responsibility to keep the EPA accountable to the American people. Mr. Chairman, I ask for unanimous consent to enter into the record a letter signed by members of the Science Committee requesting that Chairman Smith invite Administrator Pruitt to testify before our committee as soon as possible. And in addition, I would like to enter into the record Chairman Smith's response to the request, stating that a hearing request is underway. We appreciate that. I urge Chairman Smith, Chairman Biggs, and the EPA to schedule this hearing quickly. The American people have an ownership stake in their environment, and they deserve to know what the EPA and Administrator's plans are, Administrator Pruitt's plans are for the EPA. Thank you, Mr. Chairman, and without objection, I'd like to enter the letter and the report, executive summary into the record.
Without objection.
Thank you, and I yield back the balance of my time.
Thank you. I now recognize the ranking member of the full committee for a statement. I don't recognize her. Thank you. I want to introduce our witnesses, and so let's do that right now. Our first witness today is Mr. Wesley Mehl, Deputy Commissioner of the Arizona State Land Department. Mr. Mehl received his bachelor's degree in political science from the University of Arizona and his law degree from Pepperdine University. He also received an LLM in real property law from the University of Miami. I'm glad to have you today. Our next witness is Mr. James Chilton, Jr. of Chilton Ranch. Mr. Chilton is a fifth-generation rancher and has received multiple awards, such as Rancher of the Year in 2002. He received his bachelor's degree as well as master's degrees in economics and political science from Arizona State University. Thank you, Mr. Chilton. Our third witness is Mr. Ken Kopocis, Adjunct Associate Professor at American University's Washington College of Law. Mr. Kopocis previously served as the Deputy Assistant Administrator in the Office of Water at the U.S. Environmental Protection Agency. He received his bachelor's degree from the University of Nebraska, Omaha, and his law degree from the Marshall Wythe School of Law of the College of William and Mary. Thank you, Mr. Kopocis. And our last witness is Mr. Reed Hopper, Senior Attorney at the Pacific Legal Foundation. Mr. Hopper previously served as an Environmental Protection Officer and Hearing Officer in the U.S. Coast Guard. He received his bachelor's degree from the University of California and his law degree from the University of the Pacific, McGeorge School of Law. I now recognize Mr. Mehl for 5 minutes to present his testimony. And I will just remind all of you that if you be sure to turn on your microphone when you start. Thank you.
Thank you, Mr. Chairman. Mr. Chairman and members of the committee, thank you for the opportunity to testify on behalf of the Arizona State Land Department. I am the Deputy Commissioner of the department. In 1915, the state formed the Land Department to manage 9.2 million acres of land that was given to us by the federal government to be held in trusts for support of our public beneficiaries. Chiefly, this is our K-12 education system. The mandate of the department is to produce optimal revenue for our trust beneficiaries. To do this, we sell land, we lease land. There are 13 beneficiaries. If we could go to the next slide. So we have 9.2 million acres of trust land. You can see trust land identified on this map as blue. We're spread throughout the state. Together, it's 1.6 times larger than Maricopa County, which is the largest county in Arizona. The next slide, please. We have 13 beneficiaries. As I said, the largest beneficiary is our K-12 education system. We also have beneficiaries of our state universities. Next slide, please. This map represents the transactions we have done historically. These are sales and leases. We lease for mineral, agriculture, and grazing purposes, and we sell. This revenue supports our trust beneficiaries. Next slide, please. As part of this mission, I'm here to discuss our experience in navigating Section 404 of the Clean Water Act. And I think our frustrations with the rule can best be illustrated with an experience that we've had in permitting actions in an area of North Phoenix, in an urban area. Particularly a subdivision, master plan community called Desert Ridge. In 1993, we sold land to a developer who master planned this area. And it's an area bordered by freeways. So the 101 freeway and the 51 freeway are an apex, and you can see that on this map. When the project was started, the first 4 or 5 subdivisions and developments were permitted under EPA or the Army Corps' nationwide 404 permit. So each of these was allowed to proceed based on its recognition that minimal impacts were made to waters of the United States. However, soon thereafter, in the early 2000s, the Corps came to the Land Department and said, no longer are we going to allow development in this manner, but instead, we are going to require an individual permit for the entire master plan area of Desert Ridge. You go to the next slide, please. So our first challenge with the rule has been the ambiguity with respect to what a project is under 404. So the Land Department doesn't build anything. And when we rely on the people we sell to develop roadways, utility corridors, or commercial development. When we had to step in and get our permit, there were a number of challenges, and I'll talk through those. The first challenge is determining jurisdiction. Regulations for 404 have been ambiguous for a number of years. In the early 2000s, the permits we received were based on some hydrology, and it's represented here. The picture on the left shows the jurisdictional delineations of 404 washes in this area. And you can see they form a web-like construct along the entirety of the property. The problem here for us is there really isn't water present in this area. These are all channels that transport stormwater drainage. So it falls in the mountains and comes through this area. But these are not streams. They are simply temporary runs of stormwater. When you have a jurisdictional delineation, you translate that into a permit with on-site mitigation. The picture on the right shows mitigation corridors in hatched blue. The major problem for the department has been developing under these on-site mitigation corridors. Desert Ridge is some of our most valuable land. It's situated at the apex of these 2 freeways. To continue selling, we have to be able to sell with affordable infrastructure. The connections between the corridors make infrastructure much more difficult. When Commissioner Atkins and I arrived...
Mr. Mehl, your 5 minutes has expired. If you can just real quickly sum up, and then we'll put your statement into the record.
Yes, I apologize. In sum, the rule makes it hard to define jurisdiction. The washes in this area have no connection to downstream traditional waterways, and that's demonstrated in a 2017 study that we just commissioned. A move toward the administration's executive order using Justice Scalia's Rapanos rationale on the 404 rule would be beneficial to the Corps, to regulated community, and to the state of Arizona. Thank you.
Thank you, Mr. Mehl. Mr. Chilton.
Chairman Biggs and distinguished committee members, thank you for having me today. My name is Jim Chilton, and I'm a fifth-generation Arizona rancher. Our ranch is adjacent to the town of Arivaca and continues south to the international boundary with Mexico. We've been in the cattle business in Arizona for 127 years. Our family all came from Texas, so I'm happy to see Texans here. We are thankful for the 2015 Water of the United States rule that has been proposed to be withdrawn. Our experience convinces us that it was an unjustifiable overreach by the Environmental Protection Agency and the Corps of Engineers. It represented a federal power grab not supported by the Clean Water Act or the Constitution. For ranches in the western United States, a requirement to obtain a Corps of Engineers Section 404 permit or other permits is time-consuming and very expensive. The map on the monitor shows Arizona, and the red X is where I wanted to put a road across a dry wash. The dark line leading north marks the end of the Brawley Wash, no connection, and the end of the dry Santa Cruz River that has no connection to a navigable river. The dark line on the left represents the lower Gila River. These are all dry rivers, not streams of flowing water. In the 1990s, I had to retain consultants and an attorney in an effort to comply with the requirements of Section 404 to put a small dirt road across a dry wash. That wash only carries water briefly during occasional rainstorms. It connects with the Brawley Wash about 10 miles west of my proposed road crossing. The dry Brawley Wash spreads out into the desert 70 miles north from the wash where I needed a ranch road. The wash is not even connected to the Santa Cruz River. The dry Santa Cruz River bed vanishes as it spreads out like fingers in the desert 68 miles south of the usually dry Gila River. The Gila River extends another 100 miles or so across the desert to the Colorado River, which is the closest year-round navigable water, and is 265 miles from the spot where I wanted to cross the dry wash. It is laughable to think that a desert wash is navigable in any way. My second experience was before the Supreme Court decision on Rapanos. I wanted to improve a small dirt road on my private property and place a culvert in the bottom of it. You'll see on the monitor the wash, and you'll see how steep it was. I used to have to drive down into the wash and up over it on my private land. However, I was told by my environmental consultant that I paid good money for, that it was a water of the United States. Well, excitedly, I read the Rapanos decision several years later after I had abandoned the dry wash road I decided it's easier to drive down and up than hire attorneys and consultants to go through the Section 404 process. However, I abandoned the project, and after reading Rapanos, I said, it doesn't have a significant impact to the Colorado River's 265 miles away, so I put in this bridge. Well, I might go to jail now if I did it again. In conclusion, the 2015 rule would have allowed the EPA and the Corps to trump states' rights to manage intrastate waterways and even dry washes. Any future rule should recognize the authority of state and local governments to make land use and water decisions. It is our position that the intrastate rivers, such as the Santa Cruz in southern Arizona, should be regulated by the state and counties, not the federal government. Any new WOTUS rule should minimize adverse impacts on farmers and ranchers and other small businesses, and it must be designed to reduce the potential for abuse through bureaucrats sitting around and expanding the interpretation. Please refer to my written testimony for precise recommendations of the National Cattlemen's Beef Association and the Public Lands Council. Thank you, Mr. Chairman.
Thank you, Mr. Chilton. Mr. Kopocis.
Thank you, Chairman Biggs, Ranking Member Bonamici, and other members of the subcommittee. Thank you for the request to appear today to discuss the future for protecting water quality under the Clean Water Act and the role of the states. I appear today in my personal capacity. In 1972, Congress enacted the Clean Water Act to store and maintain the integrity of the nation's waters. If a water subject to the Act is not going to be polluted or destroyed, it does not come under the authority of the Clean Water Act. Congress has also created significant roles for the states in the implementation of the Clean Water Act, often referred to as cooperative federalism. The Trump EPA has put forward a false choice that providing protection against polluting and destroying water bodies somehow is adverse to states' interests. Today, most of the day-to-day activities for implementing the Clean Water Act are carried out by the states. States decide how clean their waters will be, not EPA. Plus, a significant number of states have not challenged the Clean Water Rule, and their interests are adversely affected by the proposed rollback. Further reducing the scope of the Clean Water Act will only reduce state efforts to protect waters from pollution and destruction by eliminating their federal partner. The Trump administration is pursuing a policy of repeal and retreat. Repeal the Clean Water Rule and retreat to jurisdiction based on the excessively narrow plurality opinion in Rapanos. But that opinion was expressly rejected by 5 of the 9 justices of the court. A Scalia-based rule is guaranteed to continue the post-Rapanos confusion and litigation for many, many years to come, and it is not likely to withstand judicial challenge. A Scalia-based rule also has adverse practical effects for protecting state waters from pollution and destruction. Eliminating the protection for intermittent and ephemeral streams will remove Clean Water Act protection for as much as 60% of the nation's waters, and in some areas this could be 80 to 90%. These waters would no longer be protected by water quality standards. No Clean Water Act permits would be required for discharges of pollutants. Funding to address municipal wastewater, stormwater, and non-point source pollution would be less available, and federal authority to respond to oil spills would be curtailed. While some argue that states can and will fill this void, since the scope of the Clean Water Act was limited in 2001 and 2006, there is no evidence that any state has done so. The Act refers to navigable waters, which Congress defined as waters of the United States, including the territorial seas. The Supreme Court has considered this definition 3 times, and in each case, every justice has agreed that the term navigable waters applies to waters beyond those considered to be traditionally navigable. This debate should be over. Although neither Swank nor Rapanos invalidated the agency's regulations, the EPA and the Corps spent several years developing the Clean Water Rule in response to demands of interested parties across the entire interested spectrum. Yet the Trump administration's current plans for repeal and retreat will bring back the confusion and litigation everyone said they wanted to end. The agencies developed a rule based upon Justice Kennedy's significant nexus test, a test that would have the support of 5 of the 9 justices on the court, unlike the Scalia standard, which only had 4. The rule is supported and informed by the best available peer-reviewed science on the relationship of waters and the impacts of upstream waters on downstream and adjacent waters. The validity and credibility of the science used by the agencies to support the Clean Water Rule has not been seriously denied or refuted. If there is better science, then bring it to the attention of the public and the agencies for their consideration. The rule establishes which waters will be jurisdictional in which circumstances and expanded the list of waters that would not be subject to jurisdiction. People would, for the first time, be able to read the rule and better know that a water body or feature was or was not subject to the Act, and without the need for an expert or an individual analysis. The rule also establishes transparency in how the agencies will make significant nexus determinations, instead of leaving those decisions within the discretion of an agency employee. For greater detail, I attach the rule to my testimony. The Clean Water Rule is a carefully considered rule that was developed with unprecedented public engagement and comment. It was available for public comment for 207 days. During that period, EPA held over 400 public meetings, and I personally attended about 70 of those in my prior capacity, including multiple visits to farms. Unfortunately, the rule's benefits of clarity, predictability, and consistency have been put on hold, but that will be resolved. The Trump administration does a disservice to the public with its path of repeal and retreat. It will only continue the post-Rapanos confusion and litigation for many, many years. The work of the Clean Water Act is far from finished. State-generated water quality reports indicate hundreds of impaired waters in need of reduced pollution and increased protection. Narrowing the scope of the Act does not advance these joint state and federal efforts. No one ever says that the water in our rivers, lakes, streams, and ponds is too clean, there are too many healthy fish to catch and eat, or that drinking water is too clean and abundant. The Trump policy of repeal and retreat only imperils the integrity of our nation's waters. Thank you, and I'm happy to answer any questions you may have.
Thank you, Mr. Kopocis. Mr. Hopper.
Thank you, Chairman Biggs and honorable committee members for this opportunity. I'd like to address 3 particular questions. The first is, why is it important to be precise in identifying the waters of the United States? The simple answer is that the designation of waters of the United States affects millions of property owners nationwide, and the impact on these property owners is quite severe. When an area is designated as subject to the Clean Water Act, it essentially gives the federal government complete control over that property, allowing it to exercise a veto power over the land use. It also leaves the landowner in a no-win situation. The landowner who has designated property really only has a few options. Number one, they could simply abandon all use of the property at ruinous cost. They could get a permit, which has been estimated to cost for an individual permit $270,000 and 800 days in processing, or they can simply go forward without federal approval and risk civil fines of $75,000 a day and or criminal prosecution. In addition, if the designation of the scope of the Clean Water Act is not properly drawn, it raises constitutional questions relating to due process, impingement on state rights, and exceedance of the commerce power. The second question is the revision of the 2015 WOTUS rule justified? Again, the short answer is yes. 2 courts have already determined on a preliminary basis that on its face, the 2015 WOTUS rule is probably invalid because it is likely overbroad in that it overextends or exaggerates the significant nexus test under Rapanos and is incompatible with the Swank decision, which prohibited the regulation of isolated water bodies. Also, the distance limitations the courts held are likely arbitrary and not supported by scientific evidence. In addition, the final rule doesn't look like the proposed rule, which denied the public proper notice and opportunity for comment. More importantly, these courts held that in order to protect the state's primary responsibility to regulate local land and water use and to avoid the diminishment of state sovereignty, that the rules needed to be stayed, not only locally but nationwide. And one of the courts also stated that in order to protect the public from overreaching government, the rule needed to be enjoined. Another reason why it's appropriate to revise the rule is, as I outlined in my law review article called Running Down the Controlling Opinion in Rapanos versus United States, all 9 justices, not 5 or 4, but all 9 justices would agree that when you use the Scalia plurality test and find jurisdiction, Justice Kennedy would agree, and the 4 in the dissent would agree, so all 9 justices would concur. That these factors not only justify, but necessitate pushing the reset button on the WOTUS rule. Finally, the third question I would address is, where do we go from here? I think the real problem is not so much the language we're dealing with, but with the inability or unwillingness of the agency to show some constraint. The EPA and the Corps of Engineers need to focus on protecting core water resources instead of pushing the envelope on federal power by prosecuting minor or imaginary infractions, such as digging a ditch, creating a stock pond, as in our Johnson case, plowing farmland, as in our Doherty case, building a house in a built-out subdivision, as in our Sackett case, or asserting jurisdiction over isolated water bodies, as in our Hawks case. Justice Roberts took the Corps of Engineers and the EPA to task in the Rapanos decision for not heeding the direction of the Supreme Court in the Swank case, and said that the agencies continue to rely on a boundless interpretation of the act, which is not justified. So what do we do? How do we constrain the agencies? There are 2 possibilities. One is a legislative fix. This would be more appropriate because it would clarify congressional intent and is more defensible legally. The other one is a regulatory fix with specific language, more constrained than the WOTUS rule, relying on the Scalia plurality. And for specifics on a proposal, I refer you to my written testimony, page 15. Thank you very much.
Thank you, Mr. Hopper. Now recognize myself for my 5 minutes of questions. Mr. Mehl, since the rule has been stayed, you have a chance now to voice your concerns and discuss a mutual path forward for water regulations. The question is, do you think water regulations in this country need updating? And if so, what revisions do you think would be helpful and necessary, particularly in light of Arizona's case? Please turn on your mic. Thank you.
Excuse me. Yes, absolutely. I think some changes need to be made for clarity. At least in Arizona's case, you have a high degree of prevalence of dry washes, especially in alluvial wash areas where water comes off mountains and sort of spreads out over the land, creating a high degree of complexity in analyzing where waters are and where waters aren't with respect to the existing rules. The 2015 rule resolved ambiguity in preference of total inclusion. But there's a high cost of this. There's a high cost in terms of what you pay for the analysis and just in the overall land taken through that rule. Where in Arizona, where you have only a short number of days of rainfall a year, and there just simply isn't much water in a system, you need to be able to use land for its highest and best purpose. And that's the mission of the State Land Department. If you have a rule that can show clearly what is and what is not included in jurisdiction, then you create a great benefit. And I think on the environmental side, you preserve what should be preserved and leave for development what should be higher density to prevent further sprawl and other environmental problems.
Thank you, Mr. Mehl. And Mr. Chilton, 5 generations raising cattle in Arizona, That's not an easy thing to do. And with these regulations, do you know of besides the couple that you've mentioned, your projects on your ranch, do you know of other ranchers that have had to abandon projects because the permitting process was too expensive and time-consuming?
I do not know of other ranches who have had to abandon projects. Basically, ranchers avoid having to bump up against the EPA and the Corps of Engineers. It's costly. It's outrageous that if you want to build a road on your private land and drive across a wash, that you have to get a permit. And Mr. Hopper's point about the costs of permitting is outrageous. We need, and other ranchers need, a clear definition of a significant nexus with a navigable river. Thank you.
Thank you. And Mr. Hopper, my understanding is that the EPA expanded the various definitions of water in its rulemaking. Does this potentially increase EPA's jurisdiction to regulate private property?
Excuse me, yes, the EPA claims that their new rule only expands 3 to 4% of the area that they previously recognized. However, you have to keep in mind that, as I just mentioned in my testimony, that the Supreme Court, particularly Justice Roberts, has already castigated the agencies for exceeding their authority and using a boundless interpretation. So this is 3 to 4% in addition to the boundless interpretation on which they've already relied.
Have you seen any other federal agencies attempting to expand their jurisdiction like we're seeing here out of EPA?
Yes. The Fish and Wildlife Service has done the same under the Endangered Species Act. And in fact, we have a case now pending in the Supreme Court to address this very issue called Marco versus U.S. Fish and Wildlife Service.
Great, thank you. I'm going to go ahead and yield back and recognize the ranking member of the subcommittee, Ms. Bonamici.
Thank you, Mr. Chairman. The Supreme Court plurality decision in Rapanos created an uncertain regulatory environment, and the Clean Water Rule is the result of the decision by the EPA and the Army Corps to provide regulatory clarity in light of the Rapanos decision and to better define waters of the United States. And this effort involved considering how to address the two distinct tests in Rapano, one by Justice Kennedy and one by Justice Scalia, about what constitutes a water of the United States. And every federal court of appeals decision to consider this question, including one just 2 days ago in United States versus Robertson in the Ninth Circuit, has held that Justice Kennedy's test to define a water of the United States is a valid test to apply. Now, some have held that either test can be used. However, some critics of the Clean Water Rule suggest that Justice Scalia's test should be the exclusive test. The reason federal courts have used Justice Kennedy's test as an appropriate basis for determining what is protected is because of Supreme Court precedent describing how plurality decisions should be interpreted. This precedent makes clear that Justice Kennedy's test, at a minimum, should be used, and that Justice Scalia's test should not be the exclusive basis for protection. Mr. Kopocis, in light of these federal court decisions, is there any legally justifiable reason for using Justice Scalia's test as the exclusive basis for Clean Water Act coverage?
No, there is not. When I was at the agency, our Office of General Counsel consulted extensively with the Department of Justice as to how to best interpret the Rapanos case and how to apply it. And it was the decision of all of the attorneys involved that the precedent from the Supreme Court was very clear as to how to interpret a plurality decision, and that's been reflected in all of the circuit courts to date that have ruled on the issue.
Thank you. And Mr. Kopocis, I've heard from some Oregonians. They've expressed some concern that the Clean Water Rule might affect their family farms and how they manage their lands. And you heard Mr. Chilton's story. What would you say in response to those who express those concerns?
We at the agency, in developing the rule, took the interests of agricultural properties very much into consideration. We expanded upon the existing agricultural exclusions from jurisdiction, which is significant because if it's outside of the jurisdiction of the Act, you don't even have to worry about whether a permit is required. We preserved all of the existing exclusions from jurisdiction, the ones for prior converted cropland, for example, all the permit exclusions or exemptions that are in the Act. We even went back in response to the comments and specifically excluded the concept of puddles. The agencies had long said that puddles were not jurisdictional in their informal documents. But we didn't think it was necessary to put that in the proposal, but we were criticized for not doing so. So we put it back in. We wanted to make sure that there was no ambiguity, that things such as puddles, erosional features, and the like on agricultural lands or any other land would not be jurisdictional.
And you heard the testimony this morning by the other witnesses. Are the points that they brought up any different from the points that were brought up during the whole Clean Water Rule public comment process?
No, we received, as you said, over 1 million comments on the rule. They covered every aspect of what the agency should or should not do from the standpoint of the proposal, plus also how to make the program work better. We carefully evaluated all of those comments, and we made changes to the rule based on those comments.
And could you also address the issue of the ephemeral or intermittent streams and elaborate on the role that intermittent and ephemeral streams play in the health of downstream waters? And also, and there's just a minute left, but could you also talk about wetlands and considering the great economic and environmental benefits associated with wetlands, what would be the consequences of wetland habitat if the Clean Water Rule were not implemented?
Well, intermittent and ephemeral streams are the feeder streams of all of our nation's rivers, lakes, ponds, et cetera. So if they are destroyed or polluted, then you will not be able to protect the larger water bodies. Because it's simply impossible. They are basically the capillaries of the circulatory system of the hydrologic cycle. It is important. And it's also important to note that the agencies have long asserted jurisdiction over intermittent and ephemeral streams. This is not a concept that was new to the rule. As to the value of wetlands, the values of wetlands have been stated multiple times and have been calculated. But there are tens of millions of people who spend billions of dollars a year in wetlands-related activities. And that can be monetized. There is also the value of wetlands that it provides in terms of water quality and storm water retention and reducing floods. If anybody doubts the value of wetlands, they don't need to look farther than the state of Louisiana, which is spending billions of dollars to restore their coastal Louisiana wetlands to protect the city of New Orleans and other communities.
Thank you. My time has expired. Thank you, Mr. Chairman.
Thank you. The Chair recognizes the Vice Chair of the Subcommittee, Mr. Banks from Indiana.
Thank you, Mr. Chairman, and thank you for holding this important hearing today. After hearing the testimony, I am more convinced than ever that the original WOTUS rule is an assault on transparency and accountable government. It was overly vague, it ignored the legitimate concerns raised by farmers, ranchers, and business owners, utilized an overly broad interpretation of navigable waters unjustified by the underlying statute, and encroached on the rights of states to regulate waters within their jurisdictions. I was proud to lead a letter earlier this year to Secretary Pruitt in support of the agency's decision to review and rescind the original rule, while also urging for its permanent withdrawal. I'm glad that the administration is taking this issue seriously by working to roll back this rule. WOTUS is a great example of what is wrong with our current regulatory process. Instead of working with stakeholders and carefully weighing trade-offs, the EPA looked to punish farmers and ranchers with no concern as to the rule's detrimental effects. The rule failed to acknowledge any limits on its own authority by ignoring the plain text of the Clean Water Act as well as the Supreme Court precedent in order to implement its ideological agenda. Unelected bureaucrats making laws is a direct threat to our constitutional system of government, and it is our job as elected representatives to make sure that these gross oversteps are stopped. So with that, Mr. Hopper, in your testimony, you write, quote, on its face, the rule conflicts with the language of the Clean Water Act and Supreme Court cases interpreting the act. The rule also usurps the traditional power of the states to manage local land and water resources and nullifies constitutional limits on federal authority, end quote. Your testimony then goes on into detail about the lack of scientific jurisdiction or justification for the rule and the regulatory overreach of the EPA. So with that, could you provide a brief overview again of the ways that the EPA overstepped its authority of the rule?
Yes, thank you for the question. I would refer you not merely to my testimony, but to what my testimony relies on, which is the conclusion of the District Court of North Dakota, as well as the Sixth Circuit, which arrived at those same conclusions. Even if the Kennedy test were to be the applicable standard, these courts found that the agency exceeded the significant nexus standard. In addition, it seems obvious to me that as we look back at the 2001 Swank decision, wherein the Supreme Court said that the regulation of ponds and mudflats exceeded the traditional power of the states to regulate local land and water use and raise constitutional questions, that the same thing applies here. So I think if you simply look at what the Supreme Court has already said, what the two courts said that have stayed the rule, and one's own reading and common sense suggest that this goes beyond any statutory or constitutional limit recognized by the court so far.
Okay. There are nearly 12,000 farms in my district. And since a severe rainstorm could create standing water on every farm, it is conceivable that every one of the farms I represent could have been subject to this rule. So as a follow-up, what kind of effect, do you agree with that? Could a severe rainstorm create a standing water on every farm that could be subject to the rule? And what kind of effect would that have on agricultural output?
In 2012, Pacific Legal Foundation won a unanimous Supreme Court in what's called the Sackett case, in which we challenged the right of an individual, or sought to seek the right of an individual to go to court to question federal jurisdiction when the EPA issues a compliance order. In the opinion that followed in our favor, as I said unanimously, Justice Alito himself said that under the agency's interpretation of the Clean Water Act, it covers virtually any wet spot in the country. So I would affirm what you just said.
Okay, thank you. I yield back.
Thank you. The chair recognizes the gentlelady from Hawaii, Ms. Hamabusa.
Thank you, Mr. Chair. Mr. Chair, I'd like to have unanimous consent to put into the record a 2013 report from the Environmental Law Institute entitled State Constraints, State-Imposed Limitations on the Authority of Agencies to Regulate Waters Beyond the Scope of the Federal Clean Water Act. This assessment found only half of all the states currently protect waters more stringently than the Federal Clean Water Act requires. This report determined that the states are not currently filling the gap left by the United States Court ruling limiting Clean Water Act and face significant obstacles doing so.
Without objection.
Thank you. And Mr. Chairman, I'd also like to have a letter from sportsmen and women's groups, including the National Wildlife Federation, the Theodore Roosevelt Conservation Partnership, Trout Unlimited, and the Arizona Wildlife Federation, and others, all supporting the Clean Water Act protections laid out in the Clean Water Act rule and oppose rolling back these protections. They note hunters and anglers broadly celebrated the Clean Water Rule because it would help clarify federal jurisdictions over waters of the United States and conserve roughly 60% of the stream miles and 20 million acres of wetlands at risk of being polluted or destroyed because of the jurisdictional confusion.
Without objection.
Thank you, Mr. Chair. Mr. Kopocis, I have some questions of you. First of all, you use a very interesting phrase called repeal and retreat. So what is it that you are so concerned about that the repeal of the rule would result with?
Well, repealing the rule will eliminate the advantages of the rule to provide greater clarity as to what is and is not jurisdictional under the Clean Water Act in a post-Swank and post-Rapanos world. The trouble that the agencies had to deal with, particularly after Rapanos, was that the agencies were told that the reliance on waters that the pollution or destruction of which could have an adverse effect on interstate commerce was not the test to be used. So you had a rule that was out of sync with both the Scalia opinion and the Kennedy opinion. So as the agency attempted to address that, and obviously there's some disagreement as to how successful the agency was, but the agency was trying to address that particular issue. So repealing it only restores the very confusion that everybody, and I will say everybody, whether it was the environmental community, the fish and wildlife community, it was the construction community, it was Republicans, Democrats, state, local, federal, everybody that came said, you got to fix this. And so what they're about to do is unfix it and put it back to those days. The reason I refer to retreat is that if there's going to be an effort to form a rule based on the Scalia opinion, it will cover a very narrow set of waters which will eliminate the protection for as much as 60% of the nation's waters. That is a serious, serious retreat from what this Congress enacted in 1972.
Mr. Kopocis, one of the things that I do follow is administrative rulemaking. And I did want to confirm with you that you had over 1 million public comments over a period of 207 days, and the agency held over 400 public meetings all across the country, and you personally attended about 70 of these meetings in your prior capacity, both in Washington and across the country. Can you tell me, after hearing all of this, why you still remain so firm in your belief that the rule should not be repealed?
Well, I think that when we set out to undertake it, we also set out to develop what was the best available science. And the work of our Office of Research and Development at EPA in developing that science was extensive. They originally looked at over 1,000 previously peer-reviewed documents. EPA did not create any of this science. They then, through the course of review and public comment, added another couple hundred documents to that report and came up with the conclusion on the interaction of waters and how upstream waters and their pollution or destruction affects downstream and adjacent waters. And so it was critical that the agencies apply the best available science. As I said, nobody has brought forward better science or said that the science the agencies used was bad. And then the agencies had to apply the law as interpreted both from the legislative history and the words of the Clean Water Act and as interpreted by the 3 Supreme Court cases where the court had opined.
Thank you very much. And Mr. Chair, you back.
Thank you. The chair recognizes the gentleman from California, Mr. Rohrabacher.
Thank you very much, Mr. Chairman. Let me just, we have a cattleman with us here, Mr. Chilton. Mr. Chilton, you are really not in the cattle business. You are in the money-making business. Everything you do is aimed, just like everybody else. We're working our jobs, but we really are doing it to earn a living. But in your earning your living, you're providing meat for my family, and I appreciate that. And I'd just like to know that, do these water issues impact on the price of the hamburgers that I'm buying?
I would say yes. The cattle business is one of the largest businesses in the nation, and as it's impacted adversely by bureaucrats at the Environmental Protection Agency and the Corps of Engineers, it raises the cattlemen's costs. And it's absolutely absurd to think that the rules, the 2015 rules, which were over a half-inch thick, are easy to understand. They're ambiguous, and I can't.
Did you have to hire a lawyer to?
Yes,
Now,
consultants and lawyers.
Well, let me ask about the consultants and lawyers. The fee that you had to pay them, did you add it on to the price of the meat for the hamburger that I have to buy for my kids?
No, it took away from my profits.
Okay. Well, that's good. That's a fair answer. And let me just note, if the cattlemen don't make a profit, my kids are going to pay more for their hamburger. And just like every other business, unless you take away a profitability. Now, let me ask this. When I was a kid, my family came from North Dakota and we'd go back and visit. My dad was a Marine, and we'd go back and visit our relatives. And we're relatively poor people, I might add. I remember there were on these roadsides out in the middle of nowhere, there are these gullies, and I guess ditches was a better description of them. And they'd fill up with water, and my cousins would go out and they could actually get some crawfish out of those ditches. And let me ask you this. Today, if, according to the rules, if something goes wrong with those ditches and a federal bureaucrat or federal government employee now has power, do they have power over the water in those ditches? I'd ask that, I guess, to Ken. You go right ahead.
And thank you for the opportunity to answer that question, because one of the items that we did take care of in the rule from proposal to final was we excluded virtually all of the roadside ditches from the jurisdiction. We wanted to make that clear. So the answer, I can't speak to the specifics, but it is highly much more likely than not that the ditches you described would not be jurisdiction.
So the question, the big question we have to have now is, do we really want to expand the federal definition of what those ditches are? Like you have just described, we took those ditches out. Why do we have the federal government making that determination? Shouldn't that be, I mean, that should be left up to local people. Why are local people any more less sympathetic with these important issues we're talking about, the cost of this man's doing business, or the cleanliness of the water that everybody consumes in that area? Why is the federal government more sympathetic to the needs of the people than a local bureaucrat or a local government official?
Well, that's the 2015 rule would have given all of that authority to state and local officials. By saying that these would not be jurisdictional, the federal government would have no role.
Yeah, I understand. On the ditches.
On those ditches, yes.
But not on these dried up riverbeds that we're talking about, and they will determine what's a ditch and what's a dried up riverbed. Now let me just ask one last thing. Of course, when it comes down to California, you have to understand, we were just in a big drought in California. And this was a drought that lasted 3 or 4 years. And in the middle of the drought, we had people who were so nutty that we actually channeled millions and hundreds of millions of gallons of fresh water into the ocean in order to save a little thing called delta smelt. Now, let me just note that crawfish are really important, I think, but they're not important enough to give all this power to the federal government and maybe to have some really horrible economic decisions on the industry that provides us our meat. And what we learned in California, sometimes people are so crazy and so fanatic about endangered species and things such as that, that they will hurt the well-being of regular people, as they did when they put all of that water, fresh water, into the ocean in the middle of a drought in California.
Gentleman's time has
Oh,
expired.
thank you very much, Mr.
Thank you, thank you. Chair recognizes the gentleman from Texas, Mr. Weber.
Thank you, sir. All right, here we go. I'm going to read from the President's executive order. I just can't hardly be quiet anymore if I can get my iPad here working. In his order, February 28, 2017, Section 1, Policy, it is in the national interest to ensure that the nation's navigable waters are kept free from pollution while at the same time promoting economic growth, minimizing regulatory uncertainty, which was referred to by the gentlelady from Oregon. We'll talk about that in a minute. And showing due regard for the roles of Congress and the states under the Constitution. Mr. Chairman, I'd like permission, unanimous consent to read into the record the 10th Amendment. Have it placed in the record, rather.
Without objection.
Thank you. Mr. Chilton, you said you've been farming, or you've been ranching, your family has for 127 years. Is that true?
That's exactly true, yes.
Are you glad that your great-grandparents, your grandparents, and your parents took care of the property and you were able to do the same kind of ranching?
I am.
They did a good job, didn't they?
They really did a good job, and we really have an excellent ranch with wonderful grasses, and we take care of our land.
It's in your vested interest, isn't it?
It is.
You said earlier in your testimony that you had to get a permit and you had to pay a lot of good money to an environmental attorney. Is there any other kind of money, Mr. Chilton, than good money?
All money is good.
Absolutely. And you're tired of giving it to a lawyer, right?
I hate giving it to lawyers. I hate listening to lawyers.
I don't blame you at all. Mr. Kopocis, I'm going to come to you. Is the Supreme Court ever wrong?
The Supreme Court is the law of the land. There are.
That's not what I asked. Does the Brown v. Board of Education, Plessy v. Ferguson, or Dred Scott cases ring a bell with you, where they actually reverse themselves?
Yes, yes.
Okay, so we do know that they are wrong.
They do reverse themselves from time to time.
Okay, so they do make mistakes. All right. So in your discussion, in your exchange with the gentlelady from Oregon, she made the comment that it created regulatory uncertainty. But I will tell you that the regulatory uncertainty was created long before the case got to the Supreme Court. It was created by an overreach of the federal government. The 10th Amendment, the reason I want it read into the record, is because you just got through with Dana Rohrabacher saying that the 2015 rule gave the states the authority. I would tell you that is so patently false on its face. Read your Constitution. The federal government is delineated with what their responsibilities and what their powers are by the founders of this country. All others are given to the states and the people respectively. Period. End of sentence. That's just exactly the way it is. When the federal government starts feeling like it has to dole out powers to the states, something is wrong, terribly wrong with this country. Let me continue. That's my op-ed for the minute, okay? I hope I wasn't too forceful to you. If I was, tough.
Well, perhaps,
I'm going to go to
perhaps I should have said that they basically just took the federal government out of it.
Okay.
It wasn't an affirmative
Hey,
grant
if we can
of
get you on
authority to
record for wanting to take the
states
federal
rather-
government out of the WOTUS, we're all for that. Are you on record saying you want to take the federal government out of it?
I don't believe the federal government
Okay.
can do
Mr. Hopper, I'm going to come to you. In President Trump's executive order, February 28, 17, I just read, he directs EPA and the Army Corps to consider the Scalia opinion in the Rapanos case in its revisions to WOTUS. I got two questions, really. I've got about a minute left. What is the difference between Justice Scalia's approach and Justice Kennedy's, and why does it make more sense to follow Justice Scalia's? Mr. Hopper?
First to the second question, as I outlined in my law review article, it's required by law to rely on the plurality decision authored by Justice Scalia than it is the Kennedy approach under the Supreme Court's Marks decision, which says when you have a split decision, you look at those justices who agreed in the final judgment, which would be the four in the Scalia plurality, and Justice Kennedy. You never look to the dissent. All these other courts that have held that the Kennedy test is controlling have relied on the dissent. This is
isn't that interesting?
Yeah, it is, and that's contrary to the express decision by the Supreme Court in Marks. Your other question was?
What was the difference between the approach and Kennedy?
The difference is significant. Mr. Kopocis is right that there's no question that the Scalia plurality is going to be narrower, and that's why it falls under the Marks decision. When you have two competing, concurring opinions, you look to see whether one is a subset of the other. And the Scalia plurality decision is a subset of the larger interpretation of Justice Kennedy.
Good point.
The major difference, though, however, is that under the Scalia plurality, it's fairly definite in that it describes relatively permanent tributaries and abutting wetlands that are indistinguishable. However, through the significant nexus test, it can only be applied on a case-by-case basis, and that's where the lack of clarity comes. And the WOTUS rule that was published in 2015 continues to rely on this case-by-case analysis, which gives nobody any security or certainty. Judge Kelly in the Eighth Circuit said, interestingly enough, the Clean Water Act is the only law I know of where you have to hire an expert to determine if it even applies to you.
Well,
Not to
thank you, Mr.
mention an
Hopper.
attorney.
Thank you for your indulgence, Mr. Chairman.
Thank you. The chair recognizes the gentleman from Texas, Mr. Babin.
Thank you, Mr. Chairman, and thank you, witnesses, for being here. Mr. Hopper, you mentioned in your testimony that the draft 2015 WOTUS rule and the final rule had substantial differences within it. Were these differences subject to public notice and to public comment?
Yes, absolutely. That was one of the reasons why the rule was stayed by the District Court of North Dakota and the Sixth Circuit Court of Appeal, is because there was such a substantial difference between the proposed rule and the final rule, particularly with respect to these distance limitations of 4,000 feet and the 1,500 feet and the 100-year floodplain.
Absolutely. So these changes are substantial enough to have warranted this extension period.
Without question.
Yeah, okay. And then also, in a May 29th, 2015 interview with PBS NewsHour, previous EPA Administrator Ms. Gina McCarthy stated the following, quote, "The farmers will know very clearly here that we are clearly explaining that irrigation ditches are not included. We have clearly said in the rule and beyond this rule adds absolutely no new regulatory or permitting issue for agriculture whatsoever." Do you agree with this statement?
No, in fact, I remember writing a blog post saying that the administrator is a prankster because if she had read her own rule, she'd realize that it's not clear. Even if there's been no change in the exemptions, the statutory exemptions for agriculture, that in itself constitutes a problem because the agency has a history of defining these exemptions so narrowly as to eviscerate them. For example, there's an exemption for farming. Farming practices just should not be subject to Clean Water Act jurisdiction. However, common farming practices are interpreted to mean what's common and ordinary on that particular farm, not what's common and ordinary in the industry. We think that's bogus, undermines the exemption and the statute, and I think we're going to see the same type of thing with any other exemption like ditches.
All right. So we're looking at an enormous overreach by unelected federal bureaucracy.
By any definition.
Absolutely. Okay, and then Mr. Chilton, how can a landowner possibly be expected to know prior to any digging that any water encountered would be, quote, groundwater, and therefore exempt or shallow subsurface, and therefore subject to the Clean Water Act requirements or even to fines?
Well, most farmers and ranchers want to do a good job and earn a living. And you can't really determine when you have an ambiguous, overreaching rule that isn't easily understood. I don't know how you tell the difference between a groundwater issue and whether it's a surface water issue. It's very difficult, and one has to, under the 2015 rule, hire consultants and attorneys to answer that question. Is there a significant impact? In our area, the Santa Cruz River doesn't even reach a navigable river. I mean, it's outrageous the way the county of Pima has to go through all the treacherous paperwork that is imposed on them by the Environmental Protection Agency and the Corps of Engineers when the Santa Cruz River doesn't even reach a navigable river. It's outrageous. And in terms of groundwater, let the state control what is groundwater, what is surface water. It's difficult. It's ambiguous, and it's expensive. We have an overreaching federal government. Remember, the states created the federal government. And now the federal government is ruling with an iron hand, and I hate to say this, Ken, but bureaucrats like you are overreaching. It's outrageous.
Thank you, Mr. Chilton. My time has expired, Mr. Chairman.
Thank you.
Appreciate it, though.
Thank you. The chair recognizes the gentleman from Georgia, Mr. Loudermilk.
Thank you, Mr. Chairman. Thank all the panel for being here. I want to just open with one quick question, yes or no question. Commissioner Mehl, do you agree with the Waters of the U.S. rule? Yes.
No, sir, I do not.
No. Mr. Chilton, do you agree with it?
Absolutely no.
Mr. Hopper, do you agree with it? 75% of our panel just said no, they don't agree with it, but Mr. Kopocis, back in August of this year, you co-authored an op-ed on the Hill that was entitled, "Trump Plans to Roll Back Environmental Rule Everyone Agrees On." Can you define who everyone is? I mean, when I go back to my district, I do not hear this, that everyone agrees with it. So I think that the title may be a bit misleading at the best, but I would say that's kind of consistent from what I've seen in the 3 years I've been in Congress with the EPA has a history of using any means or method to achieve a goal that it wants, regardless of fact, law, or public opinion. And I want to address some of those issues with you today. I think possibly maybe some of the reason you say everyone agrees with this rule is, as you said several times in your statement and responding to questions, was there was unprecedented public comment. And I believe I read somewhere recently that you or someone commented that 87.1% of those commented in favor of the waters of the U.S. Do you recall that?
I don't believe that was a statement that I made.
Okay, but I mean,
that sounds about right.
Okay, the majority of the people were in favor of it. But it's interesting because the New York Times came out in 2015 with an article that uncovered that the agency was actually involved in what the GAO has now determined was an illegal social media campaign called Thunderclap. Are you familiar with that?
Yes, I am.
You're familiar with that. So, in fact, one of your colleagues at the American University stated that the agency is supposed to be more of an honest broker, not a partisan advocate in the process. Now, I was surprised to learn that the agency was actually using social media to generate support for Waters of the U.S. In fact, through a FOIA request by Judicial Watch, the former EPA Director of Web Communications admitted that she did not want, quote, it to look like EPA used its own social media accounts to gain support for the rule, even though you partnered with Sierra Club and some other grassroots organizations. In fact, as I mentioned, the Government Accounting Office stated that you had violated publicity or propaganda and anti-lobbying provisions contained in Appropriations Acts in association with its Waters of the U.S. rulemaking. So, do you agree with the statements of your colleague? In fact, again, Professor Lubber said that a guide to federal agency rulemaking, I have not seen before from a federal agency this stark of an effort to generate endorsements of a proposal during an open comment period. Were you aware of the thunderclap and the generating of popular public opinion during this rulemaking period?
I became aware of the thunderclap incident after it had occurred. I was not. That was something that was handled by our communications staff. We did. I'm familiar with the GAO letter on the issue, where they found some minor violations of the appropriations law. The agency disagreed with the agency's conclusion, with GAO's conclusions, as did the Department of Justice.
Okay, well, I think most of the people in the country expect our agencies to, when you have a public comment period, to be honest brokers and listening to public opinion, not generating public opinion. But again, and I'll close with this, I think it's been in the history of the agency following this. In 2015, Science Committee obtained documents from the EPA demonstrating the EPA had avoided the regulatory impact analysis process at the Office of Management and Budget. If you recall, there was a question that you have to do an impact analysis if a rule or regulation exceeds a certain fiscal impact on the nation, which was the question. Could we bring up the slide, please? Okay, this was an email that we actually brought up in a hearing when we had Director McCarthy in a while back, and I want you to follow along. Let's start at the bottom of the email. This was an email from Jim Pendergrass, who I think you're familiar with, and basically in the second sentence of the first paragraph in the last part says, you relayed to us that Greg Peck said the rule now considered significant that OMB was unlikely to change that designation, and basically that you have to do this impact study. It went on in the second paragraph that the rule is now considered economically significant by OMB. So it would require this impact study. If you go up to the next email, so just got off the phone with Sandy and Tamika. They say that Nancy and Ken know that an RIA may be necessary, but that there are some economically significant rules the EPA haven't had an RIA, even though the law says you have to do it.
The gentleman's time has expired. Perhaps Mr. Higgins, who's next on the list, will yield you some time.
30 seconds.
He yields 30 seconds, Mr. Loudermilk.
Thank you, Mr. Chairman. And with this, at last, good news. Tamika and Sandy talked to Ken. Ken said it has been agreed that we do not need an RIA. This kind of fits into what we've seen is that the law doesn't matter. The public opinion obviously doesn't matter, and rules don't matter. Do you think that it's acceptable just to make an opinion that you don't need an impact analysis and then go forward with that?
The requirement to do the impact analysis comes out of an executive order, does not come out of a statute or the public laws. It is something that is routinely negotiated between the agencies and the Office of Management and Budget, their Office of Information and Regulatory Affairs, OIRA. And that is something that there were extensive conversations between the agency and OIRA.
Did Gina McCarthy negotiate that?
I am not, I don't recall that Gina McCarthy was personally involved.
Thank you. The chair recognizes the gentleman from Louisiana, Mr. Higgins.
Thank you, Mr. Chairman. In the interest of time, I'll ask your answers to be brief. Mr. Kopocis testified that the 2015 Waters of the U.S. rule used the best science available. Mr. Hopper, do you agree that the rule used sound science and the best science available?
Answer is no, and the two courts agreed.
Thank you for your answer. Mr. Kopocis, thank you for appearing before us today. Are you familiar with the enumerated powers of our Constitution?
Yes.
Article 2, Sections 2 and 3 gives the President constitutional authority to issue proclamations and orders. Thereby, according to constitutional parameters, the 2015 Waters of the U.S. rule, as amended by President Obama, would be legal. Don't you agree?
I'm sorry, I didn't follow the question, Mr. Higgins.
In other words, his executive authority for altering of rules at the federal level granted to the President of the United States. So,
yes, sir.
President Obama's ruling was legal. Do you agree?
The clean water rule that was
amended.
2015 was yes, I believe it was legally
Right.
promulgated.
So if it was constitutionally sound for President Obama to alter the rule, don't you agree that it's constitutionally sound for President Trump to do the same?
Oh, I don't raise any question about his constitutional authority.
All right, let's move forward. I'd like to give you an example, sir, of a town that exists within the district I represent, South Louisiana. This is a small town of just a few thousand folks. It's economically sound. A railroad runs through it. Those folks work hard to develop their community, and they, of course, have to deal with rain. Decades ago, at the southern parameters of that municipality, a ditch was dug a 12-mile ditch was dug through private property owned by 5 Americans, all of whom have family, they've grown up together, they've known each other for generations, they have family within this community. This drainage ditch was designed to collect the rainwater and runoff and bring it to a more major navigable waterway 12 miles through private land. Over the course of decades, the ditch deteriorated. And because of the 2015's Water of the U.S. rule, although this municipality of American citizens and the 5 private landowners that own the land where the original ditch was established were not allowed to reestablish the original parameters of this relatively small ditch through their own land because of the interpretations of the waters of the U.S. regarding wetlands. Do you feel that that's reflective of our Founding Fathers' intent regarding the union of 50 sovereign states and the rights of the citizens that live therein?
Well, first of all, I'm a little puzzled as to how the 2015 rule could have affected this ditch, since it was in effect for only a matter of a few days. It's been on state.
Because the interpretation of the Corps of Engineers determined that that private land was wetlands based on broad interpretations from one Corps command and control center to the next.
Well, Mr. Higgins, the waters in question may have been jurisdictional, and they may have been jurisdictional since 1972. I really can't speak to the specifics.
I'll just ask you as an American, sir, do you think that's right, that a private landowner cannot reestablish a ditch that's decades old to allow water to flow to protect his neighboring community?
The gentleman's time has expired. If you choose to answer, Mr. Kopocis, you may.
Thank you. I will briefly, that since 1977, the service and maintenance of existing ditches is exempt from permitting requirements under the Clean Water Act. And as to your point as to private property, a lot of the waters that are subject to the Clean Water Act jurisdiction are on private property. If we were to exclude all waters that are on private property, the only waters left would be those that form interstate boundaries or are on federal land.
Thank you, Mr. Chairman.
Thank you. The chair recognizes the gentleman from South Carolina, Mr. Norman.
First of all, I want to thank each of you for taking the time. Ms. Chilton, your experiences with what you went through with trying to cut a small ditch is ridiculous, and it's unelected bureaucrats who are causing this country more trouble. And my response back to most of them, let you pay for it. But Mr. Mehl, let me ask you, the EPA under the previous administrations claimed that they are not regulating land with this rule. If you regulate water in a real sense, aren't you really regulating land use? And even though the agency has said it does not intend to take over private property, how can the agency deny that by expanding vastly its definition of the waters of the United States, it's effectively is limiting the activities that can occur on your private property? Is this not the case?
Yes, sir. The rule does affect land use. Obviously, it affects densities, it affects configurations of what you can develop. In Arizona, where you have situations where water spreads over large areas, you have a tremendous impact, as you really have to make decisions about what goes where, and those are traditionally decisions made at a local level about zoning. And with respect to the water, it's not even with a question of polluting or preventing water from going from one place to the other, because largely engineering will do that. We want to develop certain lands. You can direct the water around these developments so that they go from the same point A to the same point B, and are only subject to fill such as dirt and concrete and steel. The true impact is on what you can do with that land, and so it is a land use regulation, and it is tremendously destructive for value.
And that's the effect of you basically taking somebody's private land.
Yes.
Mr. Chilton, the 2015 WOTUS rules sought to regulate isolated water bodies like dry washes. This is a significant stretch in the federal authority from the previous interpretations of the waters of the U.S. How would regulations over these isolated water bodies impact your operation? And you've got a pretty big operation, and other agricultural operations in Arizona.
First, our dry washes run into other dry washes that run into dry rivers and dissipate, as Mr. Mehl says, in the desert. They never reach the Colorado River. And for us to have to try to judge under the 2015 rule what is or isn't a water of the United States, and some sort of language saying high water mark, I kind of think of Noah. What was the high water mark when Noah was there? Do we have to, does that mean all the world is subject to the 2015 rule? I mean, why do we have to live under the rule of the EPA and the Corps of Engineers? It's very expensive, it's costly, and it's time-consuming.
Well, I appreciate you expressing your views, and it's sad to read in our notes what you had to go through. And, you know, the money that you had to spend, that's one truck that you can't buy. That's one hiree that you can't put food on the table with a salary. So I appreciate you telling your side of the story and being willing to come up and express your concern. Thank you so much. I yield back.
Thank you. And we appreciate the interest of some members, members of the whole committee who are here for the subcommittee because of the interest on this important issue. And so I recognize them for their patience, and we'll recognize first Mr. Tonko for New York.
Thank you, Mr. Chair. I have letters from more than 250 scientists and the Society of Wetland Scientists who strongly oppose a repeal of the Clean Water Rule. They note that the rule is supported overwhelmingly by scientific evidence and that a repeal of the rule, and I quote, poses a significant threat to the integrity and security of our drinking water, public health, fisheries, and wildlife habitat, close quote. So I ask, Mr. Chair, that these letters be included in the record.
Without objection.
Thank you. Every life and every job in this country depends on clean water. We must protect this precious resource and not throw away all the progress we have made. Earlier this year, members of the House Sustainable Energy and Environment Coalition, or SEEC, led a comment letter to EPA opposing Administrator Pruitt's efforts to rescind the Clean Water Rule. Since the 1970s, we have learned so much about our waterways. Years of research and peer-reviewed science have told us that the waters of the United States are connected. What we do to one will impact the health and the safety of another. The Clean Water Rule protects the drinking water of roughly 1/3 of Americans. 117 million Americans rely on drinking water sources fed by intermittent or ephemeral streams. Rolling back this rule also jeopardizes waterways that Americans use for recreation. The bottom line is Americans need an EPA that will use the best possible science to protect our health and our natural heritage. In his testimony, Mr. Hopper claims that the Clean Water Rule is not supported by scientific evidence. To the contrary, EPA issued a comprehensive science report known as the Connectivity Report, which reviewed and summarized the relevant peer-reviewed scientific literature. Mr. Kopocis, how do you respond to the claim that the Clean Water Rule is unsupported by scientific evidence?
Well, quite frankly, sir, thank you for the question. I find it to be a little troubling in how to answer that because typically when science is disputed, somebody brings science to the table and says, well, I disagree with your science and here's my science as to why. To date, the opponents of the rule have not brought forward credible science to counter what the agency put together. And as I said in my opening remarks, the agency did not create any of the science associated with the Connectivity Report. It was based on about 1,200 previously peer-reviewed studies and articles that had been put together by the experts in the field. EPA's compilation then was subject to public comment. It was sent to the Independent Science Advisory Board for its views. a science advisory panel that was made up of 27 experts in the field. They held public meetings and reviewed the document, and ultimately came with the final document and the conclusions that were contained therein. As I said, since that time, nobody has come forward and said, I have science that debunks yours.
And just why is this connectivity report so important?
Well, when Justice Kennedy, in his opinion, opined on the significant nexus test, he said it was the relationship of waters upstream to downstream that was important. Those downstream waters, of course, the upstream relationship to downstream waters that are navigable waters, jurisdictional waters. And so because the agencies in the past had looked at the effects on interstate commerce instead of how waters were interconnected with each other, it was important for us to develop that science so that we could be informed on where the Clean Water Act jurisdiction starts and where it ends. And it was important to know that some of the waters that that the science report suggested could be jurisdictional under the Clean Water Act were not included in the final rule.
And in terms of informing us or policymakers as to any future actions to repeal or replace the rule, what role does the connectivity report play?
Well, the connectivity report is there. If the agency follows its path and issues a new rule, it is going to have to explain why it does not follow the science that the agency itself already prepared and already sent through the public process.
And in your testimony, you discussed the importance of clean water to the nation's economy, listing a number of businesses and industries that need a reliable supply of clean water to function. Can you elaborate on the role of clean water in supporting the American economy, please?
Well, the clean water is important and required for virtually every aspect of the American economy. There is no sector of the economy that can exist without fresh, clean, and abundant water. When companies come to look at creating a new factory or a new endeavor, they look at what is the availability of water. Whether that's the soft drink industry, Coca-Cola spends enormous amounts of money trying to figure out where fresh water is available. Manufacturers use water, farmers use water. It's virtually every segment of society it uses water and has to have it in adequate and clean supply.
Thank you very much. Mr. Chair, I yield back.
Thank you. The chair recognizes the very patient gentleman from California, Mr. Takano.
Thank you, Mr. Chairman. I appreciate the opportunity. Mr. Kopocis, before I begin, Mr. Chairman, I have a letter from 60 different groups around the country, including Earth Justice, the League of Conservation Voters, the Natural Resources Defense Council, Alaska Wilderness League, the Puget Sound Keeper Alliance, all supporting the clean water protections laid out in the Clean Water Rule and opposing rollbacks of the rule. I ask that this letter be included in the record.
Without objection.
Thank you, Mr. Chairman. Mr. Kopocis, the witnesses today have identified many problems they think exist with the Clean Water Rule, and I wanted to give you an opportunity to address some of the concerns raised in their written testimony directly. If you could briefly respond to each of these concerns. A, why is the conclusion of all tributaries legal, in the rule, legal?
The rule actually doesn't include all tributaries. For the first time, it placed restrictions on the definition of what constitutes a tributary. The old rule used to refer to the presence of an ordinary high water mark. The new rule says that ordinary high water mark, plus there has to be a bed and banks. So there would be water bodies that could be thought of and would be thought of as tributaries that would be excluded under the new rule. It does not cover all tributaries.
Okay, so actually, compared to the old rule, this
Correct.
new rule actually
it's more narrow. Because it's more specific in the physical requirements to be considered a tributary.
Well, is the definition of adjacent waters overbroad?
No. In fact, it's been interesting that many of the criticisms of the definition of adjacency have focused on the distance limitations, the use of the 100-year floodplain, the 4,000 feet, the 1,500 feet, et cetera. And the proposal, what went out was floodplains and riparian areas without limitation. So the limitations that are in the final rule that are being criticized as overly broad are in fact limitations on what was in the proposal.
Thank you. Does the rule contain an invalid inclusion of isolated waters?
No. There is obviously some disagreement as to the holding in Swank. That case said that it was inappropriate for the agencies to rely on the presence of migratory birds to assert jurisdiction over an intrastate isolated water, and the agencies don't do that. the agencies have always looked at isolated waters and have been able to find jurisdiction under other theories. And Justice Kennedy, in particular, said that it was, in fact, sometimes the lack of a physical connection that provided the nexus to the downstream water.
Thank you very much for that. Did EPA fail to provide notice and comment of substantive rule changes?
No. Every one of the changes that we made from proposal to final were part of the test, the legal test of a logical outgrowth. In the proposal, we asked over 50 specific questions for commenters, asking them for their views on a variety of issues, including items such as what was the correct floodplain, how should we define the riparian area, are there limits, what should the agency do? So no, we do not believe so.
Thank you. Does the rule
I shouldn't say
exceed...
we, the agency.
The agency. Thank you. Thank you for that. Does the rule exceed the scope of the commerce power?
Well, the agency, working within the agency and the Department of Justice, believes the answer is no. Obviously, the ultimate decision on the stretch of Congress's power under the Commerce Clause will be made by the Supreme Court. It's an issue they've ducked 3 times.
Okay. Is the rule flagrantly disregarding the principles of federalism and usurping the rights of states?
No, it does not usurp the rights of the states. The states have always been free to do whatever they choose to do in addition under the Clean Water Act, and some states have done so. They have more stringent requirements, or they apply state law to waters that are not subject to federal jurisdiction. I find it ironic that when people talk about usurping state powers, the Clean Water Act only restricts the ability for people to pollute or destroy waters. So if states' powers are being somehow usurped, it would be the power of the state to destroy or pollute their own waters.
Well, Mr. Kopocis, I've had the privilege of being able to travel to many countries that are extraordinarily beautiful, but I find that the management of the water, whether it's near the ocean, whether it's near a river or a creek, in a populated area, can often be disappointing. I will smell the waft of pollution, human pollution, and it strikes me that one of the great things about our country is the impressive reliability from community to community, that we can trust the water systems to actually not have to rely on bottled water if we don't want to buy the bottled water. But in America, we have a tremendous trust in water from jurisdiction to jurisdiction. That's my experience. Thank you so much for your response.
Thank you.
Appreciate it.
Thank you. The chair recognizes the gentleman from Virginia, Mr. Byer.
Mr. Chairman, thank you. Thank you all for coming. I want to begin just by defending unelected bureaucrats, also known as civil servants. You know, it's the character of our governments at every level, state, local, federal, that determines the quality of our lives, the health of our economy, the health of our ranches. And these are our police, our military, education, virtually every part, and they're all unelected bureaucrats. And they fulfill the duties and the obligations that we, the Congress, gives them, or county government, state government. So a government without unelected bureaucrats is no government at all. And all we have to do is look at the lawless, ungoverned nations around the world right now and think we don't want to live there. So let's be careful about trashing these people. They are there to serve us. And by the way, much as we like elected, it's sort of difficult to imagine having elected members of Congress or even the county to determine what can happen on every given ditch or river or land use project. Like, I want to start off in line with what my friend Barry Loudermilk did by asking you a yes or no question down the line, starting with Mr. Mehl. Do you believe it's important for the American public to be able to offer their opinions, like you are today, on the nature of federal oversight for our water?
Yes, sir.
Mehl, yes. Mr. Chilton, should there be public input on this?
There should be public input, but it's a local matter, not a federal matter.
Mr. Kopocis?
Yes, absolutely.
And Mr. Hopper?
Yes.
Yeah, and I think that's what Mr. Loudermilk was trying to point out, too, when he had the debate about social media. That's why I was so dismayed when twice Republican leadership tried to sneak into the appropriations bill language that would suspend the comment period on the current administration's efforts to repeal the rule. And as you suggest, Mr. Kopocis, there's nothing illegitimate about the current administration trying to change the rule, as previous administrations have also. But we do believe the public deserves to have a say on this. And Republican leadership should stop trying to sneak in provisions to eliminate public comment. I want to raise this issue to make sure that we all have a chance to do this. I also want to highlight that we're reviewing the Clean Water Rule in the Science Committee. And naturally, the average American would think that the Science Committee would be weighing the scientific merits of the rule, but that's not what we have today. We have a witness panel that doesn't have scientists. We have administrative, legal, land management experience, ranching experience. But the key thing to note is that the Clean Water Rule was stayed by the courts, is now awaiting consideration by the Supreme Court. They just had an oral argument. So it makes sense to have legal and administrative experts, but the rule was never put in place. So let's just make the assumption that the arguments against the never enacted Clean Water Rule are justified, and that what we're hearing today are not just lobbyist talking points relayed from industries that wanted dirtier drinking water. Mr. Kopocis, you're the clean water expert here. And Mr. Chilton said that the rule is overly burdensome and would regulate the small dry washes on his estate, the dirt road they wanted to put across. In his testimony, claims that the Clean Water Rule does not respect private property. Is this true? Is this your perspective?
No, I don't agree with that assertion. Obviously, I can't speak to whether that feature he had in his photograph was jurisdictional or not. It's very hard to say from a photograph. I would say that the ability to construct a road crossing on a small water body like that is authorized by a nationwide permit by the Corps of Engineers. I don't know why it would not have qualified for that on Mr. Chilton's ranch.
Yeah, I want to also highlight how drastically different the administrations have been on their engagement on this issue. We only recently received Secretary Pruitt's calendar thanks to a FOIA request by journalists, and something that was once very transparent in previous administrations. And now we know unequivocally that unlike his predecessor in the Obama administration, Mr. Pruitt's done very little engagement with anyone beyond industry hostile to this rule. In fact, he appeared in a National Cattlemen's Beefs Association video as secretary lobbying against the Clean Water Rule. And there's now an active investigation into whether this action is a violation of his role as secretary. The administration should be listening to scientists, not industry that wants to dump or endanger our drinking water. And that's why I led a letter with Mrs. Johnson and Ms. Bonamici to Chairman Smith asking that Mr. Pruitt testify before this committee. So we deserve answers for this concerning behavior of ignoring science and focusing on industry lobbying. The mission of the EPA is to protect the human health and the environment, not work for industry's whims. And Mr. Pruitt is still not confirmed to testify before our committee. We deserve better. Mr. Chair, I yield back.
Thank you, and appreciate all the members and their very interesting questions, but I most especially express gratitude to our panel. Very excellent testimony, and the record will remain open for 2 weeks for additional comments and written questions from the members. This hearing is adjourned.